The NC Supreme Court halted the gears of the state's election apparatus until it can decide a question key to its constitution and democracy: can one party draw political maps that lock it into power for at least a decade? The order from the state's highest court pushed the primary elections back from March 8 to May 17, halted candidate filing for all political offices, and told the trial court to consider the merits of the case and rule by January 11. The decision comes after a turbulent week of reversals at lower courts where two groups alleged the political maps the Republican-led legislature passed into law are unconstitutional gerrymanders, meaning that they favor one political party more than the other. On Friday, a three-judge panel of Superior Court judges heard the lawsuits, which asked for a preliminary injunction that would stop candidate filings and push elections back to May. That court, with 2 Republicans and 1 Democrat, unanimously denied the request. Free newsletters stay informed with news and events that impact Charlotte's Black communities. The plaintiffs appeal. One group, the NC League of Conservation Voters, asked the Court of Appeals or the Supreme Court to intervene. The other group, the National Redistricting Foundation, an affiliate of the National Democratic Redistricting Committee, went straight to the NC Supreme Court. Under the current maps, political scientists project that in a state with near 50-50 voting between the major parties, Republicans would still win 10 of 14 seats for U.S. Congress, and a majority if not a veto-proof supermajority of state legislative seats. If allowed, the maps would likely bake in Republican control of the state's politics at least until maps are redrawn again after the 2030 census, when they would presumably still be in power. Flurry of legal activity on Monday, just minutes before the candidate filing opened at noon. The Court of Appeals issued an unsigned order in the league case that all candidate filing for the state legislative and congressional races would be halted until the court made a full ruling. Later that same day, the majority of the entire 15-judge Court of Appeals, which has a 10-5 Republican-Democrat split, issued an order reversing the decision, saying candidate filing could immediately reopen. The full Court of Appeals order said it would promptly make a ruling on the appeal after the defendants filed their arguments with the court. The plaintiffs in the league case then joined with plaintiffs in the foundation case to ask the NC Supreme Court to intervene. Phil Strack, a private attorney representing Republican leadership in the state legislature who are defendants in the case, filed the defense's legal response with the state Supreme Court around noon Wednesday. Only by jettisoning due process and prioritizing the unproven allegations of a select few individuals over the interests of the entire state could this court order relief, he wrote.